So good afternoon everyone. Thank you for joining our webinar today. I'm Emma Waldron, WCVA's Risk Procurement and Governance Manager, and I'm also WCVA's Data Protection Officer. So this will be our 11th webinar of the Desktop Data series, and with GDPR fast approaching, we need to be confident that we are well prepared ahead of the new regulations coming in May this year. Our speaker is Bethan Bonsall from the Information Commissioner's Office. Welcome, Bethan.
Hello.
Bethan is the ICO's lead policy officer, and she is here today to discuss contracts, liabilities and GDPR. We anticipate today's session will take no longer than 30 minutes, and there's an opportunity to ask questions afterwards. Please also feel free to add any questions to the chat pane during the session, and we'll aim to answer them at the end of the presentation. There will also be an opportunity to share your comments by completing a short survey, which we will share the details of on the final slide. Okay, so over to you, Bethan.
Thanks, Emma, and good afternoon to you all, and thanks for joining us for what is our penultimate desktop data webinar, so the 11th one, and it's scary how fast a year goes. During this session, we'll be looking at an area that's changing quite significantly on May the 25th, and that is the issue of contracts and liabilities between your charity and any third party that you use to process personal data on your charity's behalf. This webinar isn't just for those organisations who use third parties to do something with personal data on their behalf, but it's equally applicable to those third parties who are doing the job for another organisation. So it's essential that ahead of the law changing, both sides of the fence, so both data processors and controllers, understand the reasons for these changes, as well as their new responsibilities and liabilities. Now, this can be quite a techie topic, maybe quite an overwhelming one for those that aren't as familiar with current requirements, but just to kind of reassure you all that all of today's advice comes from our contracts and liabilities guidance, which is within our wider guide to the GDPR. So I'll put a screenshot of that on later. But just to reassure you that if you are unsure about anything, please don't feel overwhelmed. The ICO is here to help, and our contracts and liabilities guidance will certainly be useful if you've got any questions or if I've spoken about something a bit too fast and you'd like to know a bit more detail. So before we make a start, data protection has some key terms that would be useful for you to understand both for this webinar and also when you visit our website to look at the guidance that I've already mentioned. I've used some of these terms already, so let's take a quick look at some of the key definitions. So personal data. Now, personal data is a term used to describe any information that identifies a living individual. Personal data also includes any information which, when put together with other available information, would enable the identification of a living individual. Now, personal data covers information in any media, so it could be on paper or computer, photographs, CCTV images, voice recordings, or biometric data. All of the information that you hold on computers or other electronic devices is in scope of the GDPR, as is all hard copy information in any type of structured filing system. And it also covers information that's waiting to be added to your computer or hard copy files. Now, there's a subsection of personal data that we call sensitive data under the current Data Protection Act, but under GDPR this term changes to special category data, but it's very similar in definition. So it's information about a person's health, nationality, beliefs and political opinions, trade union membership, sexuality, and alleged or actual criminal offences. Now, because of their nature, the kind of nature of sensitivity, these types of data require additional protection. And then data subjects is another definition that we do use when talking about GDPR. So data subjects are the individuals whose data your charity uses, whether they're service users, donors, staff, or any other contacts. Data subjects have some pretty strong legal rights over how you use their data. So processing simply means everything that you do with someone's personal information, and that's from the moment you get it to the moment when you securely destroy it, and everything in between as well. So that includes the obvious work you do with data, such as collecting data from service users or volunteers, for example, but also the less obvious stuff, such as archiving, leaving it in the car, putting it in the recycling, saving it to a USB device, or even sending it to a mobile phone. So it's all processing. It's not just information that you're actively looking at. It's anything, pretty much everything that you do hold as a charity. So quite a wide encompassing definition. So more key terms under the GDPR. GDPR doesn't change the definition of data processors and data controllers, but it does amend their responsibilities, which is obviously the focus of today's webinar. If you're trying to identify where you might use a data processor, or whether you're a data controller or processor in a certain situation, have a look at our guidance on identifying the difference between the two and what the governance implications are. GDPR doesn't change the definition, as I just said, so this guidance still remains valid. And we'll have a look on the next slide of some examples of where you might be using a processor. So back to the definition. So data controllers basically determine the manner in which and the purposes for which data is processed. They must demonstrate due diligence, so it's the responsibility of the data controller only to appoint a data processor who can offer sufficient guarantees about their ability to comply with the GDPR. So we've mentioned data processors quite a few times already, but it's basically the third party who's doing something to personal data on your behalf and is acting on your documented instructions. A processor might sometimes decide to use another processor to do something with personal data on its behalf. So for shorthand, this is sometimes referred to as a sub-processor, although this isn't a kind of term defined from GDPR, but it's kind of referred to as a sub-processor just for ease. So before employing a sub-processor, the original data processor must inform you as the data controller and obtain your written permission in order for them to kind of sub-process that processing out. So many of you listening today might already be aware of the types of data processors you're using, but I thought it would just be useful to have a quick look at the types of areas that you may well be using a processor in. So it's absolutely essential that you identify all of your data processors before May 25th, because contracts need to be revised and amended as necessary by the time GDPR comes into force. So it's not something to do when it comes around. Contracts between data controllers and processors need to be amended by 25th of May, because that's when the law changes and that's what the ICO will be regulating. So let's have a quick think about the types of processors you may be using. So if you can think of any examples of any third party that do something to personal data on your instructions, it'd be great if you could just type these in the chat comments, or the chat pane, which should be on your screen. So we'll go through some examples, but if anyone can think of a few, just to start us off, that'd be great.
Okay, so we have one comment, payroll, another which is a membership system, a CRM. Great. Any other comments from anybody else? Okay, just a few more coming in now. So, yeah, well, IT contractors, that's right, yeah. HR platform, cloud provider.
Brilliant.
And it looks like we've got 3 more coming in. So, student registers, reports by freelance tutors, crime data management, research services, comms platform, mass emailing and surveying.
A nice few examples. And again, back to my earlier point, if you're thinking, do we or don't we use a data processor? There's a lot of examples where sometimes the lines might be a bit blurred, so I would always urge you, if you're unsure, have a look at our guidance on determining the differences between processors and controllers. But those examples are really good. It's really nice to get started off. Shredding is one as well that's just come through. So thanks everyone. It's always just nice to get that bit of kind of interaction, just so we can see what your thoughts on data processors are. So thanks everyone. So yeah, we've already had a few of these examples, but things such as shredding providers, so any third party that comes in to collect any confidential waste, they would be acting on your instructions, so they would be a processor. And things like IT providers, so if you've got people that look after your IT and as part of that they've got access to personal data, then those companies would also be a processor. So just to kind of summarize, any areas that you're using a processor in, so you're giving a third party a certain job to do when they're acting on your instructions, that's where you would need a contract in place for. Or it could be that you're listening in your own capacity as a data processor, in which case this is equally going to be as valid to you, because we'll see throughout this webinar the kind of areas where you as a processor or controller are likely to be responsible and liable. So thanks everyone for your contribution. So Now that we've established some of the key terms under data protection law, and we've had a look at the types of data processors you might be using or that you might be acting as, let's look at what's changing for data processors under the GDPR. So the biggest change comes from the fact that under the Data Protection Act, all liability rested with the data controller, so with the organisation that was telling that third party what to do. But now, under the GDPR, processors will for the first time have their own areas of liability and responsibility in relation to the data that they're processing. So let's look at some of these in more detail. So first of all, if a data processor wanted to subcontract their processing to a sub-processor, as we've already looked at, they would only be able to do so with written prior authorization from the data controller, and that's key. It can't just be a conversation, it's got to be written authorization from that controller saying that yes, you can go ahead and use a sub-processor for the processing in question. Another responsibility that data processors have directly is that they must cooperate with the relevant supervisory authority when required, which in the UK would be the Information Commissioner's Office. Data processors must also ensure that they've implemented appropriate security measures to look after the personal data that they're processing. So this includes technical, physical and organisational security measures. So things such as staff training, policies and procedures, etc. are a really kind of strong way to demonstrate that organisational security. Processors must, for the first time, keep records of the processing that they do on your behalf. So we've got useful guidance on our website, which can be found if you search for the term documentation in the ICO search box. So our website is ico.org.uk. There's a nice little search facility in the top right hand corner, so if you simply type the word documentation in, that links to our really useful guidance, which also has, rather handily, 2 Excel templates. So there's one for controllers and one for processors. So if you haven't had a look at those, they're really useful. So hopefully, after this webinar, you can go and have a look and you'll hopefully find them as useful as most organisations have so far. If a data processor becomes aware of a personal data breach, then they must let the data controller know without any undue delay as soon as they become aware of it. So that's a key responsibility under GDPR. If the nature of the processing requires, data processors will find that they will need to appoint a data protection officer in certain circumstances. So not all, but certainly in certain areas where the nature of the processing does suggest that they need a DPO. And finally, if your data processor is based outside of the EU, then they'll need to appoint a representative within the EU if they are indeed established outside of the European Union. So let's look at the issue of contracts between controllers and processors and why contracts are so important. The first point to note is that if you currently use a data processor, so you're using a third party to process data on your behalf, under the current Data Protection Act, you already need a contract in place in order to meet your obligations under Principle 7 of the Data Protection Act, which is the principle relating to security of personal data. So it's really important to note that this issue of contracts isn't a new one that GDPR introduces. It's already an area, where you already need a legally kind of enforceable contract to meet your current data protection requirements. However, GDPR extends what's required in a contract, as the aim of a contract isn't just to ensure compliance with security of data, as it is under Data Protection Act at the moment, but rather compliance with GDPR as a whole. Can everyone hear us now? We just lost sound temporarily. If you could type in the chat box if you can hear us. Brill. Right, what I'll do, everyone's probably pretty much lost all of this slide in terms of sound. So I'll start from the beginning again if that's okay. So sorry for those of you that have heard some of this. So we were just about to start having a look at why contracts between data controllers and processors are so important. The first point to note is that if you currently already use a data processor, so if you use a third party to process data on your behalf, you already need a contract in place in order to meet your obligations under Principle 7 of the current Data Protection Act. So many of you may know that Principle 7 relates to the security measures that an organisation must have in order to look after the data that they're processing. So that's a really key point to note, that this issue of having contracts between controllers and processors is certainly not a new requirement under GDPR. GDPR, however, does extend what's required in a contract, as the aim of a contract isn't just to ensure compliance with security of data, but rather compliance with GDPR as a whole. So it can also increase, a benefit of a contract, it can also increase the confidence that a data subject has in your charity if they know the processing is covered by a robust contract. So it's all about making sure that that individual has kind of trust and faith in your organisation, that when you are using a processor, you're doing so in compliance with the law. So how big a change this is really does depend on your charity's current arrangements. Some organisations out there may already include many of the increased requirements that GDPR asks for in their current contracts as a matter of good practice. So those organisations won't see much of a change other than the fact that good practice now becomes law under the GDPR. So that's about the importance of contracts. Now let's look at what contracts under the GDPR should include, because there are certain kind of requirements and certain terms that all contracts must include. So first of all, the contract must set out the subject matter and the duration of the processing in question. It must address the nature and the purpose of the processing. It must refer to the type of personal data being processed and the categories of data subjects. And it must refer to obligations and the rights of the data controller. And again, please don't panic that I'm going through this quite fast, because there are plenty more kind of detailed guidance available in our contracts and liabilities guidance. Contracts under the GDPR must include the following terms as a minimum. So some of these terms are terms that we've already looked at when we discussed the new areas of responsibility for data processors. So let's go through them one by one. So the contracts must stipulate that a data processor must only act on written instructions from a data controller, except when the law requires them to do so. Data processors must ensure that they obtain a commitment of confidentiality from all workers who will process that data, unless they're already under such a duty by law. Contracts must require that the data processor ensures appropriate security. So security measures include things such as encryption, having resilient systems, and the ability to back up systems. But we've already spoken about the fact that it's not just about technical and physical security, it's also about that issue of organisational security, so having good staff training, policies and procedures, etc. to back that security up. The contract must set out that the processor only engages a sub-processor with written consent from the controller. So even when they do have written consent, it's really important to note that the original processor is the organisation that will be liable to the data controller for the sub-processor's compliance. So this is important because it basically means that a processor can't subcontract their data protection responsibilities. GDPR compliant contracts will set out whether the processor is to delete or return data at the end of a contract. We'll look briefly at what rights individuals have under GDPR, and we'll look at them in more detail in the next webinar next month. But in the meantime, their importance is really emphasised by the fact that another required term in contracts under GDPR will be for the data processor to assist the controller with all of the individual's rights as necessary. Contracts should include the fact that the processor must assist the controller in meeting its GDPR obligations in relation to things such as the security of processing, the nature of personal data breaches, and data protection impact assessments where these are required under the law. Data processor contracts will also need to include the requirement for processors to submit to audits and inspections, and the requirement to provide the controller with whatever information it needs to ensure that they're both meeting their GDPR obligations. And finally, contracts should require that data processors tell the data controller immediately if they've been asked to break data protection law. So this slide really kind of covers all of the required terms that absolutely need to be inserted into contracts between controllers and processors. So now that we've seen the increased terms that need to be addressed by contracts, and we've looked at the importance of having contracts in the first place, what can data processors and controllers be potentially liable for if data protection goes wrong? So firstly, a processor can be liable to pay compensation for damage caused by processing, and it can also be subject to ICO investigatory or corrective action. So this includes receiving a fine for breaching data protection law, which many of you may know at the moment is a maximum of £500,000. It might be useful just to see whether anyone's aware of what that can go up to under the GDPR. So if anyone's aware of the maximum that we can fine under the GDPR, are you happy to just type in the comments box? If, again, it doesn't matter if you're right or wrong, because I'm happy to, I've got the answer right here. But it'll just be interesting just to see whether anyone's aware of what that maximum level of fine can go up to compared to the current Data Protection Act. So, Brill, someone's mentioned 4% of turnover. That's one strand to it. So, yes, that's brilliant, because it's the maximum that the ICO can fine up to is 20 million euros, which is around 17 million pounds, and 4%, or 4% of annual worldwide turnover. So, whichever's the highest. So that kind of does really hone in on the fact that this is a very serious area. Personal data is an asset. Organisations need to be treating it as such. And when the law does go wrong, although we're not going out with the aim to fine organisations, 25th of May onwards, those powers are there for us to use should we need to. So we don't use them in anywhere near amount of, the amount of cases that we look into. But those monetary powers are available to us should we need to use them. Data controllers, it's important to note, remain directly liable for compliance with all aspects of the GDPR, so that doesn't change, and they've got to demonstrate that compliance. So if this isn't achieved, then they may be liable to pay damages in legal proceedings or subject to fines or other penalties and corrective measures from the Information Commissioner's Office. So unless a data controller can prove that they were not in any way responsible for the event giving rise to the damage, they'll be fully liable for any damage caused by non-compliant processing, regardless of the fact that a data processor was used. So a controller may, however, be able to claim back all or part of the amount of compensation from their processor to the extent that it's liable. And finally, if a processor fails to meet any of the obligations we've looked at, or acts outside or against the instructions of the controller, then it may also be liable to pay damages in legal proceedings or be subject to fine or other penalties or corrective measures from the ICO. So in terms of future plans for contracts between data controllers or processors, standard contractual clauses may be provided by the European Commission or by the ICO, but none are currently available as yet. And we've also spoken about the fact that one of the controller's obligations is to only choose data processors who can provide sufficient guarantees that the requirements of the GDPR can be met, and the rights, those strong rights of the data subject protected. So in the future, using a processor which adheres to an approved code of conduct or a certain certification scheme may help data controllers to satisfy this requirement, although at the moment there are no such schemes available at present, but certainly look out on our website for any more details about kind of certain future certification schemes or codes of conduct. The increased rights that individuals will have under the GDPR are hugely important. So the ones that you can see on the screen, we've spoken about some of these in previous webinars. For example, we've covered the right to be informed when we looked at privacy notices. My colleague Helen ran a webinar on the right of subject access and how that's kind of changing under GDPR. But as you can see on the screen, there are 8 rights in total that individuals will have when the law changes. And these are the kind of backbone, the heart of the GDPR. They're very strong rights that we've all got in relation to our data. So it's therefore essential that data controllers appoint data processors who can provide those sufficient guarantees that these rights will be protected under the GDPR. So we're not going to look at these rights in any great detail today because we'll be having a look at what these mean in our final webinar next month. But in the meantime, you can find plenty more detail about when these rights would stand up in our guide to the GDPR. In terms of wider resources available for those of you listening today, we've got a self-assessment toolkit on our website which has a number of modules available which are basically there to assess your current compliance with data protection laws. One of the modules is called Getting Ready for the GDPR and includes 2 really useful checklists that you can see on the screen. So one's for data controllers, who are those organisations using processors, and there's one that processors themselves can complete. So whichever hat you're wearing today when listening to this webinar, I'd really strongly recommend having a go at completing those checklists. But these checklists are a wider they're one section of a wider, so you've got things such as information security, how to handle subject access requests, etc. So if you haven't seen those toolkits, then I really would strongly recommend having a look at our website and making use of these resources, because they are really essential and really kind of good for those organisations that want to know how they're doing at the moment. We've got our wider guide to the GDPR, which contains all of the information contained in this webinar. So the contracts and liabilities guidance I referred to earlier will feature in that guide to GDPR. So certainly download a copy of this if you haven't already. And finally, we've got a lot of support out there for charities as well. So in addition to the wider guide to GDPR, we've got tailored advice and support available for charities. So that hyperlink on the screen that you can see, or simply type in charity to our search facility on our webpage. There's a toolkit for SMEs and charities and all other organisations that want to assess their current compliance. So again, I know I've just referred to them, but they really are essential in terms of looking at what gaps you have now and how to assess your compliance, and where to kind of dot the I's and cross the T's in order to prepare effectively for GDPR. And as always, we're here in the ICO Wales Office to help with any queries you do have. So some of you listening today might have phoned our office in the past, you might have sent us an email. Please remember that we are here to help. So if you do have any questions, whether it's about contracts, wider GDPR queries, current Data Protection Act, we're certainly here to help. So please make the most of us. And that just leaves me to say thanks for your time. I really hope you found today's webinar useful. I know it was quite a whistle-stop tour of quite a big issue under GDPR. But I'll now hand back to Emma so we can see if there's any questions from you all. So thanks everyone for listening.
Thank you very much, Bethan. Okay, so now it's your opportunity to type in any questions you may have in the chat pane. So whilst you're thinking about some questions, there are just some that I'd like to pose to Bethan based on the questions that I've been getting from the sector. So some organisations use MailChimp, SurveyMonkey, Eventbrite, Google Docs, for example. So obviously they would be the controllers, but how do they put a contract in place with such large global organisations, Bethan?
So they'd likely be the processors, not controllers, because you're giving them that organisation and kind of they're acting on your instructions. So with MailChimp, it would be, here's our email database, here's the newsletter content, this is what I want you to send out. So essentially, if you've got any data processor controller relationship, contracts need to be in place by 25th of May. I know I referred to it earlier on. It's essential that they are reviewed and amended ahead of 25th of May because, in order to make sure that you're aware of where you're liable as a controller, where the processor is liable in respect of something going wrong, it is essential that those contracts are in place by 25th of May. And just to kind of recap again, that contracts aren't a new area, so it's not GDPR that's requiring you to have contracts. It's your current obligation under the current Data Protection Act to have contracts in place. But I imagine that most of those bigger companies are in the process of amending their kind of stock contracts so that, once you sign up to a processor that's as big as someone like MailChimp, they've got those GDPR compliant contracts ready to go.
Okay, brilliant, thank you. And one more question as well. So quite often there are organisations that are processors and the data controller hasn't put a contract in place. What would they do in that scenario?
So as a processor, so if you're sitting here today with your hat in, a data processing capacity, it's really important to go back to the controllers who are giving you that information, giving you their instructions and saying to them, look, the law is changing in May, we need a contract in place. Otherwise, if you're not happy to carry on doing something, then you might say, without a contract, I am absolutely not going to carry on with this processing. Because the contract, isn't just there to protect the controller, it's also to protect you as a data processor. So it's in both parties' equal interest to have a robust, legally enforceable contract.
Okay, thank you. And some questions from the attendees then. So what if we use systems like Dropbox to share information?
I suppose it would depend whether Dropbox is a processor. I imagine it would be if you're using it as a platform to kind of hold information. So again, I imagine a company like Dropbox, and the next question is about companies like MailChimp. I imagine that their kind of standard terms and conditions, or sorry, their standard contracts ahead of May will reflect the additional GDPR requirements. It's always worth speaking to legal experts as well, because we're not, the ICO aren't there to say yes or no, you are a processor or a controller. If you've got any uncertainty, if you've got any kind of questions about contracts, certainly seek legal advice, especially for those kind of nuances where, so there's another question about co-processors. It's a question, that I wouldn't be able to answer here and now, or, perhaps even after a session in more detail, because ultimately it's up to the organisation to work out what the scenario is. So for those of you that are unsure about whether there's, joint controllers, sub-processors, etc., have a look at our data processor and controller guidance. If you're unclear after that, then, there is the opportunity to go and seek your own independent legal advice to make sure you're getting it right ahead of the GDPR.
And with big firms such as MailChimp, Google, etc., just keep an eye on their websites, because I've looked myself today, and if you type in GDPR, you can see then the steps that they're taking to ensure that they are GDPR compliant by May the 25th.
Yeah, that's the same for, most big organisations have had this on their radar. Well, since 2016, really, when the kind of text of the regulation was released. Mm-hmm. But again, by 25th of May, that's when these contracts need to be in place for. Not kind of, we can start looking at it on the 25th because that's when the law's changing. Now is the time to act in respect of all GDPR preparation. Now is the time to get your house in order, and you'll find that you'll be in a much more strong, positive position, less daunted by the changes come, the middle of May when you're a few days away from GDPR coming in.
Okay, so you can see that somebody else is typing into the chat pane at the moment. So, okay, thanks for that question. The term regarding deleting or returning data, how can this be monitored? If the contract has ended and then there is a breach using data that hadn't been deleted, who is ultimately liable? The data controller or the data processor?
So that would really come down to a kind of matter of looking at that contract, because as we've just seen, one of the requirements is to stipulate what happens to data at the end of a contract. So I suppose an example would be if you told your data processor that at the end of a 2-year contract they're to securely destroy data because you don't want it back, you're giving it to them to securely destroy. If, say, for example, 3 years down the line, it emerges that that data processor still had that data, even though they clearly said in their contract they would securely destroy it, then it might well be that we would follow that case with the processor. But every scenario, in terms of any kind of enforcement issues we would look into, would really be based on their own merits. So it would very much depend on what contracts stipulated in respect of each kind of scenario.
Brilliant, thank you, Bethan, and thank you for your questions. We hope that you found this session useful. This concludes our session today. So to help us to improve future webinars, please can you complete a short survey for us using the link provided on the current slide there. This link will also be circulated to everyone who attended following this session. So next month's webinar will be the final session in our desktop data series. And with only 1 month to go, we will be recapping on the key areas that charities should have covered ahead of GDPR. So the final session will take place at 2 p.m. on Tuesday, the 24th of April. Thank you very much, everyone. So hopefully see you next time.
Thanks.
Bye-bye.
Bye.